Hi, we're back again, and introduce yourself again.
I'm Easy Harris, a community activist and a disabled American veteran here in Orlando, Florida.
And I'm Erwin Eisenstein, and I'll be on camera in a little bit. We're going to do another short video, and we could do a lot more, but time is of an essence, and it's getting late. And first, I'm going to read a passage, and then we're going to talk about cameras and other alternative methods that should be available in a courtroom.
What page are you on?
I'm on page 8.
Okay.
Mm-hmm. I call it a little diversion. What is the truth in court? This is from 2 United States Supreme Court cases. In re Little, which is a United States Supreme Court case from 1972, said, the lower court adjudged petitioner in contempt for stating, and this is a quote, that the court was biased and had prejudiced his case, and that petitioner was a political prisoner. The lower court found that the conduct reflected on the integrity of the court and tended to subvert and prevent justice, amounted to a finding by the district court that the words were willful and intentionally used, and that the words used tended to interrupt the court's proceedings and to impair the respect due its authority. However, the Supreme Court said there's no indication, and the state does not argue, that petitioner's statements were uttered in a boisterous tone or in any way actually disrupted the court proceeding. The Little Court, which is the Supreme Court, said that judges are supposed to be men of fortitude, able to thrive in a hardy climate. And it's quoting another case called Holt versus Virginia from 1965. In Holt, the attorneys asked the judge by motion to recuse himself, alleging that the judge was biased. The motion alleged that the judge intimidated and harassed the attorney's client. It appeared that in Holt, there were conflicts related to what occurred in court. In Little, the Supreme Court said, in this case, as in Holt, those present often have a totally different impression of the events from what would appear even in a faithful transcript of the record. And it points to Holt again at 136. These cannot be dealt with except on full ventilation of the facts. Some measure of the flavor of what really occurred in this episode and of the petitioner's attitude and demeanor, how his spoken words impressed those present, may be gleaned from the events and utterances described in the court's per curiam opinion.
Per curiam.
Per curiam means it's by the court, no one judge makes a determination. And what this means to me is that the U.S. Supreme Court recognizes that transcripts may not be the best available record of what occurs in court. Now, I'm going to excuse myself for a moment because I have this tie on and it's bothering me. Now, I know it's a little warm in here, so I'm going to take off my shirt. And Easy, what did you think of all this, taking off the tie and the shirt?
Well, you certainly can't see this if this was written in the transcript.
No, you couldn't. And how many people in court, other than a judge or lawyers, are going to say, let the record reflect that Mr. Ironstone is taking off his tie.
Not even the stenographer will have that in her written transcript.
No.
So if we had a camera in court, we would be able to see some of the actions of all the individuals that are participating in this the court proceedings.
Right. Now, there are lots of other factors that come in when you talk about cameras, and we've spoken to the media consultants in the Ninth Judicial Circuit.
Sharon Levy.
Right.
Levy. Up on the 21st floor.
I don't remember where. I didn't even
Sharon
remember.
Levy, I looked at her card.
Okay. And one of the things that she raised is, well, you can't have a second record. You only can require one record in a court, and that's the record the court uses. Now, when you have, well, you were telling me, if you have court TV and...
Like the Casey Anthony trial.
Right, and it's also recorded, there are really more than one record. And what happens is, you can use one part to verify that the other part was correct. And I've written a couple of articles about why cameras should be allowed in court and why, in fact, it should be up to the defendant as to whether they use cameras or not. And you have any opinion about that?
I don't have any doubt. I sat in a murder trial and watched the prosecutor, Kim Lewis, assistant prosecutor Kim Lewis, coach the victim's sister, where she was hysterical, crying and saying things, and he was doing like this to shut her up.
But that never appeared anywhere in a transcript.
Never appeared in a transcript, and to me that would have been just enough for her to call a mistrial, because it was at that point that she was actually one of the witnesses. She was there when her brother got killed. She was the one that said that the individual that shot her brother was wearing a red shirt. Well, the defendant didn't have a red shirt. And they realized the mistake that was made, but they still convicted him. But like I said, that stuff like this, to have a real impression of what's taking place in court, even the judge's impression, when you hand him a motion, to watch his eyes go up to the top of his head, because, it shows that he's frustrated. You can't see those things on a transcript.
You can't see them or hear them on an audio.
Right.
So the question is, who should and who shouldn't be allowed to get a camera or a video of what goes on?
Well, and the courts may say, well, if you are a injured defendant, the courts won't pay for it. Now, if you are
Donald Trump,
a rich person, or you can afford it, they may, the prosecution may not have any objection to you paying for the cost.
you mentioned that a prosecutor was prompting a witness.
Mm-hmm.
Did anyone ever say, the prosecutor's doing this? Because they couldn't, they'd be held in contempt.
And believe me, I wanted to. And they would have...
The judge was there and he saw that.
Well, it was Judge Renee Roach. And I was not impressed with her, how she handled this case. I was not even impressed with the defense attorney. And the defendant never testified at his trial.
Well, there are reasons that, people don't testify. And that's a choice.
But there was really no defense witnesses called.
Yeah. And again, you have to begin to wonder, why not? Did the defense attorney have a budget? Or did he have investigators?
No, we believe, and as I'm learning, we believe there was some negligence on that part. But this kid was convicted with circumstantial evidence. And to me, there should have not been a conviction on this case. And so, because I was there, I was watching things taking place. I'm not a lawyer. I wasn't on the juror.
You don't have to
But
be a
but
lawyer.
let me tell you something else that was very noticeable in that courtroom. One of the jurors fell asleep, and I was pissed. And I couldn't yell. I wake him up. Here you have a guy that's trying, who is really, supposed to be judging this case, and can send you to prison. And he was really the only black juror, because it was him and another guy that was an alternate, and he fell asleep.
Right.
And you can't catch that. But to me, the camera should also be pointed on the jurors, but nobody could see that. But there should be a record to reflect what the jurors are doing. I want a camera on the jurors, because if they're sleeping, that should be cause for appeal. That if half the jurors are sleeping on you during the trial, and then they find you guilty, at some point they might have missed some very important information.
I wanted to raise two things, and I believe that one case went to the United States Supreme Court because the defendant's lawyer fell asleep during a case, and I believe it was a capital case where he was charged with murder. And the Supreme Court said he was a competent lawyer. No joking. This is true. So when you talk about that, the other thing is, that prosecutor's actions were inappropriate. Absolutely. And there should have been a mistrial, and that never happens because no one captures it on a camera.
And by the way, Ken Lewis, this is the same prosecutor that posted on his Facebook that he sent the message he said to all the crack holes out there, it's never too late to get your tubes tied, straighten up your life. And there was such a backlash. The state attorney said what he does in private, it doesn't affect it. But because the outcry was great, they took him down from prosecuting any cases, and had a review of his 55 cases and found that he showed no bias. But if you
bullshit.
If you look at some of the stuff that he said about the Supreme Court Justice Sotomayor, is her name?
Right.
That she benefited in her career because of affirmative action, and if she didn't have affirmative action, she would be flipping burgers. To me, there's no doubt in my mind that Ken Lewis, assistant prosecutor for the Ninth Judicial Circuit here in Orange County, is a racist. And I would tell anybody, Ken Lewis is a racist, and Jeff Ashton should be held accountable for that, because he did not remove this guy. And I believe that Jeff won't win the next time. I hope he doesn't. But I also believe that he will not retain Ken Lewis as assistant prosecutor, because it'll be some luggage that
inappropriate.
It'd be inappropriate. But to make such statements, how does someone? I seen where out of Daytona, I seen a murder conviction overturned because the prosecutor referred to the defendant as a crackhead, and they overturned the conviction because he prejudiced the defendant in front of the juror by calling him a crackhead.
Yeah. I, have no dealings with the lawyers you're talking about,
right,
but I've seen enough to question why the judge may have fallen asleep in addition to the juror, because if you have a prosecutor who acts inappropriately, he should be sanctioned, the jury should be sent out, and he should be privately sanctioned because what he did was not appropriate. And that never happened.
Well, that happened it happened in my case a month and a half ago. The prosecutor tells the judge that Mr. Harris thinks that God is going to try his case. He actually said this. I was offended. Well, the judge says, well, if Mr. Harris loses, I don't think that God is going to come down and do his time.
That was supposedly off the record. Is that correct?
No, that was not on the record. That was They said that in open court.
Yeah, but it was off the record. It wasn't recorded.
It was recorded in court. I've got
On a transcript?
yes, and that's part of the complaint I had filed, and I told and I put that, I believe I might have put that in the motion for the judge to recuse himself. Maybe I didn't, but for them, see, the judge has a responsibility. He cannot allow someone to disparage somebody's religious beliefs. That goes to violating someone's
The First Amendment.
Which talks about freedom of speech, but religious expression. And so for him to criticize my religious, or make light of it, and then the judge, by making the statement that he did, I just felt that it was a violation, and that I would not get a fair trial under this judge.
Well, you're already in a position where you're not getting a fair trial,
Right.
because anything that lasts for 6 or 7 years,
And I'm
where
on my third judge.
where they're trying to push you to accept a plea bargain, is outrageous.
Right.
And the reason they do that, and I think I may have mentioned it, is if a person is convicted or takes a plea, they can't then later turn around and sue the state or the county
Right.
or the prosecutor.
Right.
And I've known and I've seen and observed judges who slant, I can't say because I'm not an expert in this area, but it appears that judges who are elected tend to favor the community where they are because they don't want that community to be sued for large amounts of money.
Mhm.
And, again, there's the law and there's what's practiced, and the two are very, very different. I'm going to just cite I have 2 articles that I have online at academia.edu under Irwin Ironstone. One of them is Cameras in Courts Applicable to Other States, and it's part 1. And I say it's applicable to other states because I submitted this to a judge in Florida who denied my request. The second article is Abuse in Cameras in Courts Applicable to Other States. That's also on academia.edu under Irwin Ironstone. And I was supposed to write a third article, and I haven't yet. I don't know if I ever will get around to it, but it deals with nonverbal communications. And people would say, but you're not an expert. And I have to agree, I'm not an expert. But I was married to an expert, and she used to do academic studies in referee journals. Referee journals are official journals that academics use that talk about many of the nonverbal communications that are never caught on a transcript by a transcriber, never caught even by some people who are watching because they don't know what to look for.
For instance, I'll give you a case was the Bestman Okafor case. He's smiling in court. He was charged with first-degree murder and killing a witness. He was found guilty and sentenced to death. And I had warned him. I had sent him letters, and his attorney told him not to respond to my letters. But I told him what the outcome would be in his case a couple years even before he was. But when the newspaper would put a picture of him in court, they would always most of the time, put a picture of him smiling. And jurors never want to see defendants involved with murder cases smiling in court because they think that you're disrespecting the court. And people should be very careful about that. That was one particular thing that was very noticeable about in that case. And then there was another case involving. There's a couple other cases where the transcript or what the stenographer is writing, you'll never know what actually took place in court. Besides the witness tampering, or or even a judge not paying attention. We had a case where what I did was, after this murder case, the friends of the defendant was so upset that the judge made the bailiff escort them out. And while the bailiff is escorting the friends out of court, the bailiff tells the people that he's escorting, "I can't stand the bitch. She's prejudiced." So they wrote statements to that effect. I wrote the judge and told her what was said. I did not tell who the bailiff was, but just mentioned that that it was said. And they wanted to find out who said this and that. I believe they might have moved them out of there. But this is the bailiff stating that it's his opinion that the judge is prejudiced because she made him remove the people out of the courtroom. This is the type of stuff that people really need to know what's going on, what's happening with these judges. Each and every one of them have a mind of their own. And if the police or the prosecutor don't like you, they'll try to get the judge kicked off any cases. But look at the case with Circuit Judge Tim Shea.
I don't know.
What happened was he was so upset because the police officers were not showing up in court. They were not doing the deposition. He was frustrated because they were delaying the court's time. So the prosecutor, Jeff Ashton, and the police chief, John Mina, complained to the courts that they wanted all OPD cases removed from this judge.
OPD is what?
Orlando Police Department. So that went to the Fifth Appellate, and they denied the complaint. They said that what the judge had done was understandable. It showed his frustration in police officers not showing up in court. Because Tim Shea, they felt that he was not one of those. In fact, he got the lowest rating of the recent poll by the Police Chiefs Association here in Central Florida because he's not pro-cop. And so he doesn't take lightly what cops, some judges are pro, like one of the judges.
You were talking about Judge O'Kane?
She's the top-rated circuit judge in Orange and Osceola County. And I delivered her letter to her office on I believe it was the 21st of January. I said, you must disclose to the defendant that you were selected the top judge in the circuit by the Police Chiefs Association. And now you're being asked to keep this deny him a bond because he allegedly ran over a police officer. And 12 of them show up in your court, to show support to the officer. And so what she did was she denied this kid a bond. The kid was 17 at the time. He's 18 now. He had no priors, never been in any trouble. And she denied him a bond, saying that he's a threat to society.
Well, you were denied, and your bond went all the way up. And then, surprisingly, it dropped all the way down. And one of the issues there, and you told me, I don't know if it's true or not, you were running in Orlando for the city council.
Yeah, I was running. I was a candidate. You can probably see the brochure here for Orlando City Council for District 5, and I was going to win that election. And the commissioner pretty much got the police chief to come after me and she was part of the conspiracy to say that I was selling drugs.
Very hard to prove conspiracy.
Well, we can because we have people that have signed documentation to the effect that they were going to be paid to bring false allegations against me. This is stuff I had to get, and my own attorneys didn't do it. But how this really started was when the police chief had her gun stolen, I was the one to put up the reward of $2,000 for information that anyone had, they could give it to Crime Line and they would get the reward. All hell broke loose when I put that reward up because we found out that the police chief and her husband, the sheriff of Orange County, they filed a false police report. Her gun was not stolen out of her vehicle that was parked in front of her home, which was a gated community. It didn't happen that way. She knew it didn't happen that way. So I was becoming too close to this investigation.
Are you saying that there was perjury? There was a false report? And what happened to her because of that? Nothing.
Well, we know that someone did take her bag, which had her gun, her baton, 45 rounds of ammunition, maybe a checkbook, handcuffs, and stuff like that. But there was no forced entry into her vehicle. There was no other burglaries reported that evening. Why would someone go through a closed gate in a gated community and just target the house of the sheriff of Orange County and the police chief? They would have to be out of their mind.
Yeah.
It didn't happen. And she said that she put her gun in that vehicle because she had some children that were and their families that came over to visit. Well, if she put her gun in the vehicle, why didn't her husband do it likewise?
Or why didn't they put it in the trunk?
Because it didn't happen. The burglary didn't happen. And so what happened was someone tipped off from...
Are we really going to show this on YouTube?
Yeah.
Okay.
Someone tipped off the newspaper in February 2009 that they were keeping the theft secret. So Orlando Sentinel found out that it happened. It just made news all across the state. I had owned the name ValDemmings.com, so I said, well, that'd be a great article to put up on the website. And when I put it up on the website, all hell broke loose. And I was interviewed by Channel 9. They had an article in the newspaper. My website went from 1,000 hits to 10,000 hits.
I wish I could do that.
And then people told me, and they came after me. They started targeting me, and it was that was April 2009, and this is the culmination. It was them arresting me in November. They started the investigation. Really started it much before they said they did. But they wanted to take me down, and because I was running for office, because they couldn't buy me, they knew I'd been around for many years, and that I was going to expose the corruption in city government. But for the last 6.5 years, this has been a hell of a ride experience to see the level of corruption, but not only in politics, but in our judicial system, the courts, the prosecutor's office, the misconduct that has taken place. And what I did was I filed a packet. This volume, over 250-something pages, indexed, also with the CDs that was sent to the feds. So when I sent this to the feds, and they still have my case, they said, for what you tell us, there is a pattern and practice of official misconduct, but they're non-criminal.
As soon as you have official misconduct, by definition,
Right.
It's criminal.
Right. But what I'm saying is that it's not anything they could go to jail for.
They can go to jail
Well,
for it
right.
if the federal government and the Justice Department really wants to act on something, they do.
Yeah, but this is egregious because if they only knew to the level what took place in my case, they were going to pay people to say that I was selling drugs. They were promising people that if you testify, who got caught up in something else, if you make allegations against Mr. Harris, then we won't prosecute you on this.
I know other cases, and I can't really speak openly, but it had to do with an attorney disciplinary hearing where the bar threatened her attorney and said, if you're going to talk about this area, watch your back. And that was a bar prosecutor going after an attorney. If I file a complaint or say you have 800 pages that show that a prosecutor acted improperly, nothing happens. If I tell a judge, we talked about it before, I don't even remember the case, it's I think Zolan versus U.S., where there's a crime fraud exception, where lawyers lose a lawyer-client privilege if they effectively cover up an ongoing fraud.
Mm-hmm.
The judge in this action ignored it. I sent him 300 pages, and he ignored it. And my question is, who do I report it to? If I report it to the bar, they're going to ignore it. If there's an area here for judicial misconduct, the judge said, you don't like my decision? Appeal it. But that means I will have already gone through a trial where they prevented me from presenting information showing that the Florida Supreme Court screwed up. Realize I've seen the same thing. In fact, one of the areas where, and I haven't made up my mind as to who I'm going to vote for, except I'm not going to vote for Hillary. And the reason I'm not going to vote for Hillary is there are just too many instances where she's failed to tell the truth, where she's covered things up, and just some of them are enough to say, is that the best we can do?
No, Hillary won't get elected. When the junior senator from Illinois, Barack Obama, defeated her 8 years ago, the same thing is going to happen now. Putting Hillary Clinton in office basically will be giving Bill Clinton a third term. That's not going to happen. And there's so much that the public should be, wanting to know about the Clintons, about the China Gate. See, the Monica Lewinsky case that really overshadowed what was really taking place. What they should have focused on was when the Clinton administration sold technology, missile technology, to communist China for campaign contributions. That was treason. This is worse than anything that the Rosenbergs were charged with. And so,
I can say the same thing about our current president. There are some of the things that he's done, and I've argued with his supporters, that are equivalent, I think, to treason.
Yeah, but
whether it's the FBI or whether it's the IRS that he uses to go after.
Remember, he's a puppet. That Lerner woman, she was a puppet as head of the
IRS.
Right. And what do they do, stating that they don't know where the emails are and all this other stuff? Lois Lerner, they would kill her if she opened her mouth. These people know they're not going to do something. This is much more than simply the president. He's just a puppet. There's more people behind.
Oh, I'm sure there are, I take a look. You had the selling of guns to Mexican drug lords, Fast and Furious.
Right. Mm-hmm.
I don't know. And what happened is.
And by the way, Eric Holder, he didn't think there was anything wrong with that.
Yeah. Well, he was protected. Our president said, I'm going to assert executive privilege and not allow any of this.
Right. Right.
Oop, I think that's my phone.
Yeah, don't worry about it.
Okay.
This conversation is more important. Unless it's about the dog.
No, it isn't. I have to turn this off, I hope. Okay. In any case, we've been on here for almost a half hour. And I would suggest, you can look online for the two reports on why cameras should be considered. As I say, there's one part that I haven't really put up, and it has to do with linguistics and, for example, if you can afford it, you can hire a jury selection expert. And I know I went to a class where, and I'm trying to think, I think her last name was Constantine, gave a class on nonverbal communications. And when witnesses are lying, how do you identify it? With witnesses and also with jury members, how do you identify, do you see how they react when a question is asked? Other things, for example, and I get this from my own thing, because I used to help my ex with statistical reports. Some of the issues relate to bias based on speech patterns. If you're a taxi cab driver, they'll, sort of put off. When I was going to law school, people used to laugh at me because I have a Brooklyn accent. And people from Brooklyn who have an accent are not rated the same way as a criminal from Massachusetts with a New England accent. Other differences, speaking differences. For example, if I'm Latino or Italian, we speak like this. If I'm American Protestant, the speaking distance is this far away.
Yeah, jury selection may be important. I was leaning towards not having that because it's my belief that this case would never go. All the corruption that involved with my case, I said it would never go to trial, and it's been nearly 7 years now. What I've learned in this whole process, especially over the last 6.5 years, when it comes to jurors, I can tell you in Orange County, they try very hard, especially in cases involving young black men, felony cases. They don't want black grandmothers on the juror because they know that they tend to be more forgiving than anyone. They're more sympathetic. So the prosecutor don't want any old black women on there because they know they'll feel sorry for the little soul. So they try to even not even have as little as blacks as possible on the jurors. And they seem to be doing a good job like that here in Orange County. And but people should be involved. I think there should be not only a court watch, there should be a judge watch. People should be watching the judge, watching the prosecutors, and noting this. Because I believe that law enforcement, the judges along with the prosecutors, these are just one little clique where they're supposed to be separate.
Well, that's a problem in our
system.
system.
But they're not, and I'm telling you because they all know each other. It's buddy, and they know each other from other cases. And I'm telling you, depending on your case, it's better to get someone from outside who don't even know the people, so they can't be influenced and they know the law. Because what happens is that if you're in this same circuit, retribution. Court-appointed attorneys have to watch about retribution because if they go after the wrong person, they may not have a job or have clients.
And they'll never be able to work in court again.
Right. And so if you get someone from the outside, but when you're indigent, know your rights because tell me what indigent case, and the judge says, I've never had a case like this before. I've never seen this in my 32 years. And I told him, you never had a client like this that fought for his rights. Or for his, and he probably didn't agree with me, but I take very seriously my freedom and my reputation, and they don't like people that they think that are acting disrespectful or that might show some intelligence.
Right. You were very respectful. I was watching you from the back, and I said, I wouldn't have done that. I would have probably been held in contempt, as I've been held in contempt in the past. But I was going to raise 2 points, and then we'll talk about it. First of all, you'll notice that I did a strip. And I did that because I wanted, for 2 reasons. Cameras would have identified what I was doing. The second reason is if you're a minority, dress respectfully, because if you don't, you start, as a minority, you frequently start out 2 or 3 steps behind. If you don't act respectably and if you don't wear reasonable clothes.
I can't tell you when you see these people come to court with, basically, I've seen them up on the stand where they were sagging. And if you're a defendant and you got a juror of 6 or 12, whatever it may be, you definitely don't want to have supporters coming in looking like thugs and sitting behind you. When juries hate to see gang members coming because it's like a form of intimidation. And right then and there, you're judged by your peers, and they can find you guilty based upon how your supporters look. And I just couldn't believe this guy would have all the dreads and
I have
the weed smokers and all this other stuff. You don't have these people coming to court. You're respectful. You look presentable.
It's funny because I have to say this. I can tell you what to do, but that doesn't mean that I do it.
Right.
So do what I say and not what I do.
Right. No, I'm caught up in the system, so you know that I know it. But what I've learned in this whole process, in this journey that I'm still going through, and thank Almighty God that they have not put me under the jail, I'm able to pass this information on to other people. We want to affect change, but you can't possibly have the appreciation for it unless you're stuck in it and what you really see what's really going on. But if you have anybody that's tied up in the system, give them the support. It's kind of lonely being there in jail and having never been there before, and then you're around murderers, rapists, whatever. And they had me there. Here I'm there for drug trafficking charges. I was actually on the 5th floor, and just about everybody down the row of about 8 cells were there on murder charges. And I said, why? I said to them, why am I up here with murderers? I didn't know the system, it's just...
well, that's
crazy.
an issue because there are times when state laws say you can't intermingle certain prisoners.
Right.
But because of crowding, they do it anyway.
Well, they called me a high-profile case, but that's a bunch of malarkey. I think that there was some political stuff going on downtown, too.
Right. I'm going to raise 2 things, and you may, just sort of, I don't know how to express it.
No, say it. Let's say it.
1879, it was right after the Civil War, and
6 years before my grandfather was born. But go ahead.
Right. And what it dealt with is, in the South, you had a judge, and the judge was excluding black men from juries. Mm-hmm. And the case, I believe, is Ex parte Virginia. The feds came in and locked the judge up for violating people's rights. Now, surprisingly,
the 13th Amendment did it give the blacks a right to?
Yeah.
The black men a right to vote,
right.
Am I right?
Yeah. A lot of women were very upset by that because, you had lots of women who were very well educated who didn't have the right to vote.
And there was a reason why. It had to do with the issue of property.
Oh, yes. And that came up. I was just listening to
they had no rights.
You're right. In fact, I was listening to Ruth Bader Ginsburg.
That's amazing.
Whose claim to fame is she won 5 of 6 cases related to discrimination before the Supreme Court. And some of the cases dealt with men, how they were being discriminated against. And, well, in any case, I'm going to revert back. So we have Ex parte Virginia, 1879. 1879, I
Mhm.
think, may be wrong. And then we wait about 100 years, and there's Batson versus Kentucky. And I don't know, let me just give you a quick. In Batson versus Kentucky, it found that prosecutors were excluding people from juries.
Mhm.
The case went up to the United States Supreme Court and said, "You can't do that. We ruled 100 years ago that you couldn't do it." They were excluding all types of people from juries, and usually you have ways to exclude people. You have challenges for cause, but then you have other reasons. And the other reasons can say, "I don't like the way you part your hair.
Mhm.
You're a Hispanic woman, and I'm not going to tell them that you're a Hispanic woman, and that's why I'm excluding you."
They were excluding them because of the Jim Crow laws. Remember?
Yeah, exactly.
After Reconstruction, the federal government pulled back and allowed basically the South to do whatever they wanted to do.
Yeah.
And one of the worst things that took place for 80 years after, from 1865 basically to 1945, was convict leasing. If you want to talk about something, it was slavery by another name. So what you do was that you change the laws from, you make what was misdemeanors, you make them felonies. A guy could get 5 years in prison for stealing a pig worth $1.
Yeah. Well,
And what I'm saying was, so what they would do, what the states would do was they would lease out those prisoners.
to work.
And that was the former slavery.
Right.
800,000 people, they say, they estimated that, suffered from blacks from 1865 through forced labor.
Yeah.
And
it's
crazy.
You had it in Hawaii also with
amazing.
large companies running plantations.
It's crazy. Yes.
And again,
In the coal mines, man,
Yeah.
you go to Birmingham, Alabama, to see the convict leasing program. They were called, what was that? They were called the peon laws. Remember the PEONE, peonage laws.
peonage. Yeah.
Remember that?
Yeah.
And that came out of the peons came out of Mexico. They didn't want to bring those laws on that took place when Mexico became part of the Union to become, New Mexico, whatever the case may be.
Right.
But knowing that history, was amazing what took place.
Yeah.
So, and this was worse. What you think that the blacks had freedom in 1865? No, what took place was far worse, because they would work these prisoners up until they dropped dead.
Yeah.
And it's just amazing. And so,
Yeah. I was going to add one other experience that I had in my many years of playing, and I don't call it playing because I've gone through a lot of abuse and health problems and everything else, but at one point...
Be a vegan like I am. Vegan life, man, it's the best life, a vegan. But go ahead.
Yeah. I was helping someone who was pushed down a flight of stairs by police officers.
Oh, God, you're...
And he filed a suit in federal court. And I was there to help him with jury selection. And there were things that went on, and he was really a very bright guy. He's no longer with us. His name was Martin Rodetsky.
Where does this happen at? In New York?
In New Jersey.
New Jersey?
Yeah.
God.
I used to live in New Jersey, so...
Where about?
South Orange.
Oh, I knew it was orange. I just said, don't tell me orange.
Yeah. But what happened was, during jury selection, the attorney representing the police excluded a black guy with dreads. And, I wasn't supposed to say anything, so I kicked Marty under the table, and Marty says, "Judge, I object." So I went up with Marty to the judge's sidebar, and the police attorney came up also. And I said, Judge, we're making a Batson challenge, which means you're questioning why a juror was selected based on some criteria. In this case, it was race. The judge said, excuse me, sir, you can't speak. So I went to Marty and said, Marty, tell the judge you're making a Batson challenge. So he says, Judge, I'm making a Batson challenge. The police attorney looks at the judge and says, Judge, what's a Batson challenge? And I always remember that because the judge in this case was biased. She was a state court judge, and now she was on the federal bench. I think her name was Hayden. And after she rendered a decision saying that not all of the elements were present to continue with a civil rights violation. And I'd like to spend another half hour on that, but I'm not. And I think maybe what we should do is close this out. Do you have any other things that you'd like to talk about?
No, I just enjoy just learning through the process. If I can get through this thing unscathed, I would probably go to law school, or at least I did go for paralegal. I do know how to do legal research and look at, and I can, you know, as a lay person, I can look at something and tell you if it's right or wrong. I don't have to be degreed for that.
Right.
You know, generally if we use our conscience, and if it doesn't seem right, it's not right, but for defendants, it's important that you do your research. Don't plead to something you haven't done. If you put it in God's hand, leave it there. You know, this whole journey, I tell you, it's been a remarkable experience in my life. It's been, I could not have survived this without God, knowing that all that I'm going through. To be jailed 3 different occasions for about a total for more than 6 months. A case that had gone on for going into its 7th year. To be on my 12th or 13th attorney. I'm on my 3rd judge looking for a 4th because the law says so. You just have to keep your wits about yourself and not get depressed through the whole process. If you look at my apartment, I've got papers all over the place. But I would tell people to, if I had known that this case would drag on this long, I would have documented, cataloged things much better than I have. But for what I've got now, what I've learned, I'm able to help other people. I will tell you that through this whole process that it's been rewarding, the prison and jail ministry, because you give people hope who don't have hope. And so, and there's a young man that I just got a letter from him last week, and he went in at 19 years old, and he just sent me a letter from prison saying that they found a switchblade in his cell and gave him 60 days in confinement. And he says, and the poor kid really doesn't have, and some of these kids are just so naive, they don't have any concept of time. 25 years, you know,
Yeah, I know.
To me that would be a death sentence, but they don't have. He's got more time than he's been alive. And this kid is completely innocent. But I would hope that the prosecutors will allow people that are caught up in the system, although you can't use a polygraph test in court. But I do think that we need to use that between the prosecutors and the attorneys to at least let them know what they have, maybe to a plea negotiation.
I've often thought about the polygraph, and you know, my
And
mind,
they got some advanced ones now. They got more
my
advanced
mind
ones.
is spinning, and I've had lots of experiences that are similar. And I think you know that I retired, and after I retired, I started law school at 60.
Right.
And I had a third of my stomach removed during law school because I had a cancerous tumor.
That's why you need to go to the vegan diet.
I know, but in any case, the one thing that I reflect back on is, I sued probably 4 to 5 judges. And what happened was, I think both the New York bar
Yeah.
and the Florida bar said, there's no way in hell.
That's right. That's right.
And I recognize now that you really can't sue a judge except in very limited areas. And I disagree with that, and I disagree with judicial immunity.
Right. Right.
My phone is going wild, and I'm sorry for that. And there's so much more. You raised something. I have 2 articles related to assistance of counsel on the same website.
Mm-hmm.
And what it talks about is how the Supreme Court said that people with common causes can actually assist each other. One of the famous cases is Johnson versus Avery. There are, in any case,
I think we talked about that last time.
Yeah, but in any case, they're also on the website. Judges don't look at it, they ignore it, even when you send them the issue of, I can't afford an attorney, you have me in front of you with 2 lawyers on the other side, I have a friend there who's helping me organize papers, and you ask her, are you an attorney? And she said no, and the judge says, well, you have to leave there. So in court, things are stacked against you. In Florida, it's probably even worse. They don't recognize decisions by the United States Supreme Court, either in the First Amendment area or in many other areas.
But I do believe that when you do go to court, bring as many witnesses as you can. If you're there by yourself, the judge will chew you up and spit you out. But if you have people there, they tend to will guard themselves because they, the individuals that you bring to court is acting as a camera, as a witness, and so especially if they can take shorthand or take notes. But bring as many people as you can, because I think when you came to court, there's no doubt that the judge didn't want to give me an attorney. In fact, he said that 6 months ago, this is your last attorney. Then when I told him the attorney that you gave me was defective, and I said defective, he says, well, I didn't know, but because you were there, he relented and gave me an attorney. Then he asked you who you were.
Right.
As if we were together.
I was in the back of the court. I had a t-shirt on. I had shorts,
Right.
sneakers, and you say,
And you were the only white. There were nothing but black defendants, but you were the only white guy there.
Yeah.
Who's this white guy with?
And when the judge, at the end after Easy left, I was getting up to go, and the judge said, "Excuse me, sir, who are you?" And I was looking around. I don't know who he's talking. It's got to be someone behind me. So finally he said, "No, you." But it was very funny because when you have witnesses and the judge doesn't know what goes on,
He just knew you were out of place because there was nothing but black defendants.
Right.
So who are you with?
I was telling one of my friends, black guy, that if I had done some of the things that I did and I was a black kid, I'd probably be dead. And his response was, no you wouldn't, because your mother and your sisters would tell you how to act. Because there are many different standards in this country.
Mm-hmm.
And as I say, there are racial components. I think because I'm from New York and have sued judges, there are components where they take a look at me and say, we don't want that guy. And you know, I have a Jewish background, although I don't practice and don't necessarily believe in a higher authority, but I do believe in some natural type of order. But they look at me and they say, we don't want a Jew from New York.
Oh God, no.
And they don't say that,
No.
but that's their intention.
Yeah, I'm glad you mentioned that. I hope that eventually in this country that the truth will come out about the United States government's complicity with Hitler in the extermination of the Jews. The millions of Jews that died at the hands of the Nazis could not have taken place if Washington did not allow it.
Yeah.
And if people only knew the truth about Henry Ford, about even the Bush grandfather,
Right.
who was keeping the Nazis' money in the bank in New York. It's amazing that the number of communists that were, or the Nazis that were in this country during when Hitler's rise to power.
Yeah.
Remember, in 1938, he was Time Man of the Year. Remember?
I don't.
Yes, the Time Man of the Year. But the truth, and I'm one of these people that believe, because I believe in the Word of God, I believe that the truth will come out. And I think that, speaking about the truth that you said, prosecutors' main job is not to convict the defendant, but to bring out the truth.
Yeah.
But they're not, no, they're the ones don't want the truth to come out. And this is what I'm finding, especially in my case. The worst thing that they feel is for me to get a paid attorney. They will, because now they know that I will be paying for performance. When you have an attorney, when you pay attorney for performance to do his job. But if you have a court-appointed attorney, they don't have to do their job. But we know that according to the U.S. Constitution, they're supposed to, but they don't do it. And this is why I've had to keep their feet to the fire, and I thank God that He gave me the knowledge and the ability to do this.
I think we better stop now because I don't know how much longer we're going to be recording. Okay?
All right.
Take care.
Thank you.
Easy.
Thank you.